Can an international student who is working in the United States on optional practical training keep working while their change of status to that of H-1B worker is pending? Hi, Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. We get this situation a lot where international students are somewhat confused about the timing of optional practical training and how that relates to a change of status to H-1B. So what are we talking about today? Let's say we have an international student named Fran, and Fran is from China. And Fran decides that he would like to apply through his employer for an H-1B. Fran has graduated in May. Fran has gotten his OPT application on file timely with USCIS before he graduates, and his work authorization is set to start on June 15th. And Francis has been approved for 1 year of optional practical training. So this program allows F1 international students to stay in the United States, to continue working, to remain on their F1 visa, but to work for an employer who may be willing to sponsor them for an H-1B. So let's say Francis does an outstanding job and he works June through December, January, February, March, and the employer is so happy with him that they decide on April 1st to apply for an H-1B. Well, the thing with H-1B employment visas is that they're tied to the fiscal year and they don't go into effect until the following October 1st. So in Francis's situation, the employer would file on April 1st to change his status from that of F1 international student to H-1B visa holder, but that visa wouldn't become available until October. Now Francis's employment authorization that he got through OPT is set to expire in June. So what happens between June and October? And here's the answer. Because of something called the Cap Gap extension, a regulation from USCIS that allows an international student to keep working while on OPT, to extend that OPT all the way through October 1st, they are allowed to continue working. And this is a great benefit for both the employer and the international student. Otherwise, they'd either have to stop working or they'd have to leave at the end of their EAD. But Congress and USCIS recognize that there's this time period between when a student finishes their work authorization card and when they can start work under their H-1B. So an international student who has that June to June time frame for a work authorization is allowed to remain in the United States, to stay here and to continue working for that employer who filed that H-1B visa for them. Now, the Cap Gap extension does not apply to international students who are working at institutions of higher learning. So sometimes an institution will file for an H-1B, but they won't do it because they're not subject to the cap. They can do it year-round. And sometimes the international student who's on optional practical training thinks that they're going to be entitled to some kind of extension and to be able to continue working while that's pending, and that's not true. The Cap Gap extension does not apply to H-1Bs filed by institutions of higher learning or cap-exempt organizations like that. The other thing to keep in mind with the Cap Gap extension is that, let's say that instead of having a work authorization that ran from June to June, that Francis's ran from February to February. This can cause a little bit of a problem. So in this scenario, Fran would have been a December graduate, and Fran would have gotten OPT from February to February. And we're talking not about a situation where an employer files for work for an H-1B work visa on that very first April 1st, but now we're talking about Francis is coming to the end of OPT and the employer decides they want to sponsor them for an H-1B for that following year. So the question is, if Fran's EAD expires before April 1st, can he and the employer take advantage of the Cap Gap extension? And the answer to that is yes and no. The yes part of that answer is that Fran is allowed to stay in the United States while that H-1B change of status is pending. The no part of it comes from the fact that Fran is not going to be able to continue working. So they sort of split the baby. So this is one of the reasons why you probably don't want to graduate in December and get a work authorization that runs during that time period, because you're going to have to take time off work from the employer and you're not going to be able to start back work until that H-1B becomes available on October 1st. This can be a little bit confusing. Timing is important. So if you have questions about this, make sure to give us a call, 314-961-8200, or you can email us, jim@hackinglawpractice.com. If you like this video, make sure to subscribe to our YouTube channel, and we'll see you on the next video. Thanks a lot.